All right, good afternoon and welcome to the webinar. This is the eviction process and tenant rights being hosted by Washtenaw Housing Alliance and the Housing Coordinators Network and being presented by Alex Henry from Legal Services of South Central Michigan. This is just to provide an introductory understanding for tenants and housing advocates on what the eviction process is and what tenant rights are in that process. This webinar is being recorded, so we can share it out to you later by email, and with others, we'll also be sharing that out on our website as well as our social media pages. The webinar is being, like I said, being presented by Legal Services of South Central Michigan, and this is their information, so you can we'll also send that out to you as well. So just a little bit about Washtenaw Housing Alliance. We're a coalition of over 30 nonprofit government entities that are committed to ending homelessness in our community. The Housing Coordinators Network is a collective of Washtenaw Housing Alliance member agencies and other county partners providing housing location placements and services. And to get more information, check out our website at whalliance.org. All right. And without further ado, we're going to go ahead and turn this over to Alex Henry from Legal Services of Michigan.
Hi, everyone. Thank you for that intro. Now I'm just going to share my screen. All right. Does everyone see my screen now? All right, perfect. Okay, so my name is Alex Henry. I work at Legal Services and as an attorney there, and we focus specifically on Washtenaw County is where my office is located, but all across South Central Michigan, we assist people with low income or who have other disabilities. We mostly focus on preventing homelessness, domestic violence, healthcare access, and other things like that. I specifically help with the housing docket and the assistance we provide there, mostly towards tenants who are facing eviction, but we also assist with other needs that tenants face, such as repair concerns or subsidy issues. And specifically, this presentation is accurate until pretty much this date. There's lots of changes that are going on, especially since COVID-19, that has really affected the laws regarding evictions and what protections tenants have. So this presentation will be specific toward this date and in Washtenaw County, as the way it is practiced with other judges can differ depending on which county you're in. So just to go over what we're going to be presenting and what we hope you take away from this presentation, I'm going to give a brief understanding and timeline of the events that lead up to an eviction judgment and what happens after an eviction judgment, to kind of give you an overview of what you should expect if you ever are faced with an eviction notice. Secondly, we'll look over what are the common defenses, common reasons the landlord might try to evict someone, and what a defendant might be able to do to protect themselves from being evicted. And lastly, we'll kind of go over what are some things you might be able to prepare for before you face an eviction to protect your rights and make sure that you're not unjustly evicted. So first, just to go over some things that usually a tenant could be evicted for. The most common is probably non-payment of rent. It's important to note that this can be filed, the notice for non-payment of rent can be filed as soon as you're late. So even if you are only 1 day late on your rent, they can send you a notice immediately demanding that you either pay the rent or that they will attempt to evict you from your unit. The other common ones are creating a serious or continued health hazard. Basically, that means that you're either damaging the property or you're doing something that's potentially dangerous to yourself or others, causing extensive damage. Again, this kind of falls in line with the previous one, but the idea that the property that is being rented is being damaged by the tenant. using the home for illegal activities such as drug activities, moving into the property without the owner's permission, or staying without the owner's permission. Now, there also is some specific things that someone could be evicted for, and some specific protections that they might have if they have a mobile home or if they receive a subsidy from the federal government. These are different in that they require just cause eviction from the landlord. Basically, because someone owns a mobile home, they might still be renting the lot, but the state believes that those people are entitled to more protections because of the ownership of the home. We want to make sure that just because you might be late on rent, that you would not be evicted from a home that you own. In this case, it requires just cause eviction. We're not going to be going into exactly what just cause is, but right now all you need to understand is that it's a higher bar for an eviction. It requires more than just simply minor things that otherwise you would be able to evict for. There are also reasons like the lease simply ends, or the tenant is month to month. And it's important to remember that in Michigan, you can be evicted for no reason at all. If you're month to month, the landlord is required to give you a month's notice, or however the length is between your payments of rent. If the lease ends, your landlord must also give you notice if they want to increase your rent or if they want to evict you. But if they don't give you any notice at all, it's considered to continue on as a month-to-month tenancy. But if you are a tenant and you are evicted for a month-to-month lease, it may not be any reason at all that's specified for the eviction. The landlord simply may just want to evict you for no reason at all. There are defenses in those cases, but they are much more limited and harder to prove. What's most important is to remember that evictions can't happen without going to court first. So a landlord can't simply try and move you out of the property. They can't move your belongings out of the property. They can't change the locks. They can't cut off the essential utilities such as water or electricity. If they do so, that would open them up to a lot of liability. The courts do not like this. But if the landlord tries to push you out, remember that you have the right to a hearing, and they would have to go through the proper processes to try and evict you if that's what they wanted to do. You would get a court date, you would get a notice and a summons from the court, and you would have a chance to be heard before the court before they could issue an eviction judgment. So to give an overview of the eviction process, the first step is that the tenant will receive a notice to quit or a demand for possession by the landlord. This is something that the landlord drafts up, or their attorney, and then they present it to the tenants, either by mail or in person. This, on the notice, should establish the reason they want you to leave, or the reason they think that they are entitled to evict you. So this will establish whether it was for non-payment of rent, or if it was simply that they want you out because of a month-to-month tenancy, or if they're claiming that there's some damage you're causing. There will be a notice period, depending on what infraction they're claiming you're causing, at which point you will have a chance to fix that, address it in some way, before they will then issue a summons. For example, if they're claiming non-payment of rent, typically they would have 7 days at which you could pay the rent they're claiming, or they would then begin the process to evict you. Now, the next step in the process is that they would have to go to the court with that notice. They would have to show that the notice period has passed, and then they would be able to file a complaint with the court. The court would then send you a copy of the complaint as well as a summons. Now, the summons is going to have the court date for both parties on it. It's going to be sent to both parties, and it's going to tell you exactly when you're able to go to court, so that the court can hear and decide whether the eviction will go through. Now, the third step is this argument period. this is the period of which you are going to be in court. There's going to be usually an attorney involved on behalf of your landlord. And this is where you either need to make your defenses, or you either need to work out a settlement agreement with your landlord to figure out whether you are able to stay, able to fix the problem, or if you simply want to leave to avoid an eviction judgment. It's important to remember that if you do leave before you get an eviction judgment, in some cases, such as non-payment of rent, where they're only asking for the property back, that this will actually stop you from receiving an eviction judgment on your record. That may be helpful in renting in the future. So that's something to consider when trying to fight or see if you're wanting simply to move. And of course, the fourth step is if this is all unsuccessful, if you're unable to negotiate a settlement or come up with relevant defenses that the court's willing to accept, then there will be a judgment issued. Typically, in Washtenaw County, judges will give the tenants 10 days to move after a judgment, which means that once the judgment is filed, you have 10 days to move your property. And if you do not, the landlord can go to the court again, ask for a writ of eviction. And once they grant that from the court, they can then go to the police office and have the tenant forcibly removed. So first, I wanted to talk about the most probably common reason for eviction, which is a demand for possession. And these are filed in cases where there is a claim that rent is owed. Usually the landlord will also add in things like late fees, utility fees, and court costs as well. So it's important to remember that if you get a notice of a certain amount of money owed, or you get a complaint of a certain amount of money owed, that may not be the full amount that they will be requesting in court. For example, if you get a complaint at the end of March, but your hearing isn't until April, at the point of the hearing, you will owe April's rent as well, and that will also need to be paid for the eviction case to go away. Now, like I said before, in these kinds of cases, you have 7 days to pay, or then they will file on the case. And typically in a demand for possession, unless they specifically request on their complaint later on that they will be asking for money damages, then the case can be solved by either paying the amount owed or leaving. If you leave, you may still owe money later on, but they will not be able to claim money damages in the current case they're filing. They would have to sell it to a debt collector to go after you at a later date, or they would have to go after you themselves at a later date, which is not always a guarantee. So sometimes if it's a solution, the best way to avoid these cases is simply to move out if there is a dramatic amount of money owed. The next most likely reason someone is evicted for is under a notice to quit. Now, a notice to quit typically, and not always, will give you 30 days to move out. And they're mostly done at the end of a lease or for someone who has a month-to-month tenancy. These, again, like I said before, may not have any specific reason why they're asking you to leave, which also means that there's no problem to correct. Whereas in a demand for possession, where they're asking for money, if you pay them the money, then the eviction case will go away. Whereas in a notice to quit, since they're not asking for anything, sometimes there isn't anything that you're able to do to make them stop the case against you. Now, there are defenses that you might be able to do. For example, if they file this in retaliation to you making a complaint to the city inspector about some repair issues, then you might be able to argue retaliation. If there's some kind of worry about discrimination, you could make a discrimination defense. But it also is important to remember that because they do not need to make a claim or a reason that they want you to leave, these can be more difficult to defend. So just as we were going over to kind of explain responding to the notice, when you get a notice, obviously the first thing you want to do is reach out to legal services. We can better explain what's going on in that notice and what possible defenses you might have depending on the facts of the case. Another thing you might want to do is reach out to the landlord or their attorney, who will also be written in on the notice and their contact information. Sometimes landlords will not want to talk to you once a notice has been filed. They'll just want you to talk to their attorney. And sometimes they won't even want to talk to you before the court case if they're not willing to work it out. Now, when you get the notice, you can see what the issue is. You can try and ask for clarification and see if they're unwilling to file against you if you're able to make some kind of agreement. But you also need to remember that unless there's an agreement made in writing, that they will not file the case against you. It's best to wait sometimes until a case is actually filed before you do any steps that they ask you to do as part of some kind of settlement. The other option you can do is simply do what they're asking. If they're asking for money, you can pay it. If they're asking you to move, you can move. That will also avoid the risk that you might face of eviction or an eviction judgment. And if you do these things, you also likely will not have to go to court. Now, if you do move out, and they did request that you move out, it's still important that you attend your first hearing, because you want to ensure that they let the court know that you have moved out and that your case will be dismissed. Sometimes, not always, the landlord might not know that you moved out, or they might fail to tell their attorney, at which point the attorney may get a judgment for an eviction against you, even though you've already left the property. Obviously, that's something we'd want to avoid, so it's always important to make sure, unless you're told by the court that the case has been dismissed against you, or you know for a fact that the case has not been filed yet, you should always try and attend your first hearing. Now, if you do decide to fight it, obviously you have the chance to defend yourself. You have the chance to make the court aware of whatever problems you might have. For example, some reasons that you might not be paying your rent is because the landlord is not making repairs that they should be making. Going to court will give you the chance to let the court know that and ensure that not only are you not evicted, but the court orders that those repairs are made.
Alex, we have a couple of questions.
Sure.
All right. The one question that came in is, what is the difference between a demand for possession and a summons? Department of Health and Human Services requires a tenant to submit a summons as part of the documentation to apply for state emergency relief for eviction prevention. At what point does a tenant get the summons?
So that's a good question. Thank you for bringing that up. So a demand for possession or a notice to quit, those are both things that are written by your landlord. They're written to warn you, hey, if you don't do such and such action, we're going to take you to court. A summons is when the notice period has gone by. Let's say you have a 7-day notice period of which they want you to pay the rent they're claiming is owed. Once that 7 days goes by, and let's say you didn't pay them, they'll then go to court and they'll request a summons so they can have a hearing. The summons tells you that you're going, that you have a case now in court, and it will tell you the date of which you can attend that court date, as well as how you can attend it. If there's a Zoom ID, they'll give you that Zoom ID in the summons. So what it sounds like is being asked is they want to ensure that not only has your landlord, provided you with a notice that they may take you to court, but they also have a summons that shows that you do in fact have a court case against you. I do believe that if you face that issue, that they're not willing to accept the notice to quit, that they have the summons, you can also try and reach out to us to see if we might be able to persuade them to take that on, because sometimes when you have the summons, it's already too late to get financial assistance, because the process of financial assistance can take quite a long time, and the process of the eviction proceedings can be quite quick. Were there any other questions at this time?
Yeah, a couple of other questions. Speak up.
Yeah.
Okay, a couple of other questions. If you move, you talked about moving, like, so you get the notice of quit and maybe a judgment, but if you move before the judgment is issued, do you still have to pay those funds that were being demanded? And does that go on to your credit report?
So I'm assuming this would be for a non-payment of rent case. Is that right?
Yes.
Okay.
Yes.
So here's the thing is, for a non-payment of rent case, let's say you get a summons from the court for some money owed, and then you, before the judgment is given, you agree to move out, and the case is dismissed against you, or you simply advise them that you have moved out, and the case is dismissed against you. Unless they're asking for money damages in that case, then for that specific case, they can't claim any money damages from you. That means they can't go after you for any debt owed in that case. It also means that the eviction would be dismissed, so you wouldn't have an eviction judgment on your record. Now, if you get a judgment for an eviction in a non-payment of rent case, all that same applies, but now you have an eviction judgment on your record. So it's always best, if you do believe you're going to lose, or you do believe you are able to move, that you want to move before the eviction judgment is issued, so that's going to avoid it on your record. Now, for the separate issue of the money, just because they don't get the money claim in that specific case doesn't mean they give it up. What it means is they can attempt to go after you at a later date, or they can sell it to a debt collector, who will then go after you for the money that they claim is owed. So if they do that, they would still need to go to court. They would still need to get a judgment showing that you owe that money. But if they did get that judgment showing that you owe that money, that would go on your credit report. That would mean that you would owe them or the debt collector some money. But it's important to remember that would be a second separate case that you would also be able to raise defenses in. So if there was reason you did not owe money to your landlord, and for whatever reason it wasn't brought up in the eviction case, you could bring it up at that time when they're trying to collect that debt from you.
We have a couple of more questions. Does the tenant always pay the court costs?
No, they do not. But basically how it works is, if the court finds that the tenant was in fact late on the rent, or for some reason they do believe that the tenant was at fault, I guess, for the eviction, then they would typically grant the landlord the court costs. If there's a settlement issued, you can also agree not to pay the court costs, or you can agree to pay the court costs, depending on how the settlement goes. Now, the settlement would be a discussion between you, the landlord, and their landlord's attorney on what you're willing to basically agree to make the court case go away. Whereas the court, though, they're only going to make you pay the court costs if you essentially lose your argument.
I have another question. Can the landlord change the locks if you are not out by 10 days, or do they have to get the police to get you out?
Even in that scenario where you have a judgment and it's been 10 days since the judgment, they would still need to get a writ order from the court, and they would have to get the police or another specific private provider with that writ to change the locks and move out the property. They cannot do self-help.
Can you go back to this issue of, maybe a landlord illegally evicting somebody, meaning that they change the locks or put their stuff out before the whole court case and everything? If that happens to somebody, I mean, that how quickly can that get resolved? If like you go home one afternoon and the locks have been changed, you can't get into your house, you can't get your things. I mean, how quickly can something like that get resolved?
Well, that also depends on the way of which it goes. So let's say the landlord filed a eviction case against you, and then they decided it was taking too long, so they just decided to try and lock you out themselves. In that case, at your next hearing, or even before your next hearing, you could alert the court to the fact that you have been illegally evicted from your home, at which point the court will almost certainly file an emergency order, making the landlord give you the new keys or changing the locks back. So that one could resolve itself fairly quickly, and the landlord would likely face some harsh punishments for that. Now, if you don't have a court case going on, if there's no eviction proceedings, that can take longer. You can still file a claim against your landlord in court, but then you would be the one filing it, and it would take some time for it to be issued. And it would really depend on how quickly the court processed that basically that claim that you'd be making against the landlord. The difference again would be that you would be filing the case, not your landlord. But it would almost be that you were, filing to assert your rights as a tenant. And then they would want you to show proof that you are a tenant, you haven't been evicted in any proceedings.
Thanks. We did get a question. It's in regards to Lori Terrace. We will get to that, and we do acknowledge that the person that put that question in, and we would like to have further discussion on that, but I'm not sure that this is the venue to do that, but we definitely want to have a conversation about that with them as well. And if we have time at the end, we can also maybe address some of those issues as well. We'll let you continue, Alex.
Thank you. And yes, if anyone has any specific questions, or if anyone faces, a lockout or any other issues with your landlord, even before the court case happens, please feel free to reach out to Legal Services of South Central Michigan. We also have walk-in hours every Tuesday from 10 to 12 and every Thursday from 2 to 4. And I think we'll also provide our phone number at the end of this presentation, so you can contact us at that point. All right. So just again, to kind of go over what the summons and complaint is, the summons is going to be the first paper you actually get from the courts. The notice is all from the landlord. The summons is going to be the first one you actually get from the court. And it should also have attached to it the notice that your landlord originally sent to you, as well as the complaint. The complaint will talk about in more detail what exactly it is that the landlord thinks is the reason you should be evicted. It's going to have numbered sentences on it, and it's going to detail what those accusations are that it's making. Now, this is important because the tenant has the right to answer these issues. They can do so verbally when they go to court, but they can also do it through a document you can find online called a SCAO answer, SCAO answer. And it's basically a simple thing to fill out, but really what you need to do to fill these out and to kind of explain it, this is what a complaint would look like. And if you see here, it's going to have numbers for each sentence. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And you as a defendant, if you wanted to file a physical written answer, what you would do is you would basically respond to those. So here's the first basically statement. You would respond either you agree with that statement, you disagree with that statement, or you don't know. And you would go through all these reasons. So if they're saying that it's for non-payment of rent, you would say that you either disagree that you owe that money, or you disagree that you owe that money because there might be some repair issues, or you believe you paid but they didn't have a record of it, something like that. So that's what you would want to do in these cases. And I also mentioned before, for a normal non-payment of rent case, unless they have this part filled out at the bottom called the supplemental complaint, the one written number 10, unless they have that filled out, you have the option to move and not pay what they're claiming, and you won't face any judgment for money for that case. You might get it later on. They might attempt to go after you later on, but you wouldn't have to owe them anything at that time. Because in these cases, they're only asking you to either pay or move out. You have the option of one or the other. Now, if they file a supplemental complaint asking for money damages on top of that, which is uncommon, but it does happen, then they're asking for you to move out and to pay the money. So at that point, they would also be asking for a money judgment in those cases. And if you move out, you'd still owe them money if that case went on. So again, I think we brought up some of these before, but to kind of go over what are the common defenses you might have for non-payment of rent. One thing you could simply say is the amount they're claiming is incorrect. Maybe they were overcharging you for rent, and your lease actually shows that your rent should be, $900, not $1,000. Another thing you could talk to them about is if they're charging you excessive late fees. Typically, the judges around here will cap late fees at about 10% of the monthly rent, or about $50. If the landlord failed to make repairs that they were supposed to be making, that's another reason you might be withholding your rent. In a sense, if you're not getting the full use out of your property, you don't have to pay them the full amount of rent. Now, there's specific things you want to do. If that's the case, you want to make sure that if that is the case, that you're letting the landlord know that's the reason you're withholding the rent and you're not paying them. And you want to make sure that you have a record of where you kept that money. The court likes to know that you do have the money, you just aren't giving it to them because they're not doing their end of the bargain. And then there's other things like if the landlord perhaps charges you for some repair costs that aren't your fault. Maybe there was, like a storm that caused a window to be broken that the landlord had to fix, and then they attempted to charge you for it. That's not your fault. You shouldn't have to pay that. And of course, if you have subsidized housing and for some reason your subsidy provider is late or does not pay the amount they should be paying, that's not the tenant's fault. That's not something that you would be able to be evicted for. That's something between your landlord and the subsidy provider. For a termination case, if they do allege some violation, some lease violation, the common defense obviously would be that you don't believe you violated whatever issue they're claiming, either that you're innocent of it or that you don't believe it's something of a high enough level that they can terminate you for. Another reason might be retaliation. I mentioned before, even if they don't give you a reason why they're evicting you, even if they're evicting you for no reason at all, if you believe it's because of retaliation, if you believe that you made a report to the city inspector about repair concerns and the landlord didn't like that, and you believe that's the real reason, that might be a defense you could use, even if they don't give you a reason that they're evicting you. Again, another one would be discrimination, either based on race, color, national origin, religion, sex, disability, family status, and age. Those are the specific classes in Michigan that are protected by discrimination. And it's also important to remember that, there are some things that the landlord can simply be a jerk about. Maybe they don't like you specifically. That might not be discrimination that can be protected by the court unless it falls into one of these categories. Another important defense too is that if a landlord files for an eviction on, let's say, a month-to-month basis, and they say they want you out by March, but over the process you end up paying for March's rent and April's rent, the court typically considers this as tacit implication that your landlord is willing to allow you to continue staying at the property. So if you show proof that you made payments past the time they sent you the notice and that they accepted those payments, the court will typically dismiss the case against you for eviction.
Okay, Alex, we have some more questions
Sure.
coming in. What can a resident do when they witness another resident doing something that has been identified as a cause for eviction, especially pertaining to safety, report reports it to the landlord and the landlord refuses to take action?
So that can also depend on what exactly the action is. If it's related to safety, if it's a criminal matter, you don't necessarily need to tell your landlord about it. You could tell the police if that's an issue, if it's a legal issue. If there's some reason that that issue is interfering with the quiet enjoyment of the property for the leaser, that is also something that they could bring to their attention. They could also treat it in some respects like a repair issue that your landlord isn't addressing. If they're not giving you the full benefit of the property, you may be able to withhold rent and basically force them to either address the issue or take you to court, at which point you can let the court know this issue has been going on. The reason I'm not paying rent is because this issue is going on, at which point the court would then either make the landlord address it or tell you that you need to pay rent because the court doesn't agree that that would be a big issue. But if there is specific issues that you would like to talk about, I do advise you to reach out to legal services.
Okay, this has to do with a trailer park. So this person said, I have a patient who is going to be evicted from his trailer park on April 21st. He has not paid the last few months of the trailer park's fee to keep his trailer there. What happens to his trailer even though he owns it and he claims it's too old to move?
So, and that's always the specific issues with trailer parks in general. They have certain different laws that are applicable to them. So one thing I would say is if he does own the trailer part, the home, the trailer on the property, he's only renting the lot, he does have special protections. He needs not only non-payment of rent, but he needs what's called just cause for the eviction. It's a bit of a higher standard. For non-payment of rent, he would need at least 3 months of which he wasn't paying rent. But the courts are also more lenient on that. So if he's able to come up with a payment plan, the courts are more willing to let those individuals stay and try and work that out. Other issues, though, is typically in these cases, if his property really is that old, if it's that fragile that it can't move, that might be the reason, the secret reason the landlord wants to evict him is they don't like how it looks. They want a newer mobile home there on the property. So that might be the secret reason they're doing it. So that's also something to be aware of. Now, for what happens if he does get evicted is then if you can't move the property, the landlord could also continue to go after that issue because it would essentially be his property on their land, which he is no longer allowed to be on. One thing they could do is they could simply buy the property off him, which is a pretty common thing to do. They could also basically move the property itself and try and bill him for the cost of removing that property. But again, if there is a specific issue, we do recommend that you guys reach out to us so we can look into that and see what possible defenses he might have so that he isn't evicted.
Okay, I have another question. Is there an official process to escrow withheld rent, or can a tenant hold the rent in their personal bank account, savings, or checking?
I don't know if there's a specific exact place to hold it, but I do know that there is certain ways to do it. And we can talk about this. We even have a little PDF that we can hand out that talks about this. But what you want to do is before you make any withholding of rent, you want to report the issue to the landlord. Let's say it's a repair issue that's been going on for first. You want to report the issue to the landlord, and you want to record your reporting of that. So however you did that, you want to make sure you did it the correct way that your lease says you're supposed to report it, and you want to make sure that you documented it, whether it's in writing or whatnot. Then if nothing gets done about that, then you want to contact the city inspector, and you want them to come out and see the property and basically state that, yes, this property does need to be repaired. There is some deficiency here. Now, if your landlord still doesn't do anything like that, and again, you want to make sure you're recording this. then you want to basically escrow the rent. And you can escrow the rent in lots of different ways. You can even escrow the rent with the court in some instances, but the typical way to do it is to talk to a bank and set up an escrow with them. What you would do at that point is you would alert your landlord, I will be escrowing my rent with such and such company. I will no longer be paying the rent directly to you. You will get the rent that is now in escrow when the repairs are made and not before that. Then if they do take you to court for non-payment of rent, you would be able to show the judge, I talked to them, I reached out to them, they didn't do anything. I reached out to the city inspector who demanded they do something. They still didn't do anything, at which point I withheld my rent in this escrow account. Here's the full amount that it is now. And at that point, then the court would be willing to make sure that those repairs are made. Now, if you don't follow that step perfectly, the courts will usually be willing to give you some slack because it's a rather complicated process. But the more you do, the better you do at doing that, especially at recording, those conversations you had with the landlord to make those repairs, the more likely it is the judge will agree with you. Were there any other questions at this time?
No, that's all the questions for now.
Perfect. So to talk about the court process, now that you've gotten the summons, now that you had your notice in the summons and it didn't work out, you now have your first hearing. For non-payment of rent cases, first hearing is pretty preliminary, which means they really won't do all that much in your case. You'll have, usually appearing on Zoom, you'll have your name called, and at which point you will state your name, state that you're here, and the judge will typically explain the process, explain what's going on, and then they will likely just adjourn it out for another week, advise you to either seek an attorney or to talk to the landlord's attorney and see what can be worked out. At the second hearing is when they would expect you to have an answer filed or expect you to explain your defense. At that point, the judge will determine whether they think you have a good enough defense, at which point you can go to trial. If it's a significant amount of trial, they may adjourn it for another date, or they may simply have the trial there at that moment. And then they would issue a judgment at the end of the trial, either in your favor or against you. So for a non-payment rent case, this is typically the first hearing, then you have a week, and then you have the second hearing. And that's usually the full amount of the non-payment of rent process. So you have a 7-day notice, you have the summons that comes after that, then you have the first hearing, and then the next week you have the second hearing. For a termination of tenancy case, again, you typically have the 30-day notice, then the summons, and then you're going to have that first hearing. Now, what they typically do in Washtenaw County at the first hearings is that you will be given a second hearing, but only if you request it to speak to legal services or try and work out an agreement with the landlord. If you don't, they would expect you at that first hearing to articulate your defenses and possibly have a trial on those issues if they thought your defenses were good enough. So this one could be over in one hearing. You might be able to get an adjournment for the second hearing, but beyond that, it would be very unlikely that you'd go further unless you had an attorney defending you. It's also important to remember, if you do not show up to the first hearing, you could get a default judgment. Typically, they won't do the default judgments in non-payment of rent cases if the service of the notice was done by mail. That means if they give you the notice by mail, they'll typically give you a second hearing for non-payment of rent cases. But if the service was given to you in person, then they will usually give you a default judgment if you miss your first hearing. So that's why it's important to remember you need to go to your first hearing and really all of your hearings, because if you're not there, the judge will simply rule against you. So then basically trying to go into what happens if you do get a judgment. If you go to trial and you lose, or you don't go to your hearing at all and you get defaulted, you will have 10 days to pay or leave if you're getting a non-payment of rent case. That means you have 10 days, which you can pay the amount or leave the property. If you pay the amount within those 10 days, then the judgment can be removed and you can stay. But if you don't, you will have to leave. For a termination of tenancy case, again, you have those 10 days, but you do not have any redemption amount unless it's specifically listed in the judgment. But typically for a termination of tenancy case, you're not going to have a redemption amount. You're not going to have an amount you could pay to stay. You're simply going to have to leave at the end of those 10 days. And for both these cases, what they'll typically do is they will post a 24 to 72 hour notice on your door at the end of those 10 days, at which point you need to vacate, or they will then be able to remove you. And again, this is just to outline the whole process. As you can see, it starts with the notice period and then goes to when they can file the complaint, and then the summons is sent to you, at which point the case is heard. And if there is a judgment, then you would have 10 days to move out. So as you can see, for non-payment of rent cases, from the start of the notice to the time that they could evict you after 10 days would at the shortest be about 29 days. I'd say on average, it's maybe 45 or so, but these can go very quickly. Whereas a 30-day termination of tenancy, someone could be out within 52 days, though it's typically a little bit longer. But again, these are very short, so it's important to be as prepared as possible. So what happens if you do get an eviction judgment on your record? Well, it'll be there in the future when you're trying to rent. So if you try and go to another landlord, they'll be able to see that you had an eviction judgment against you, and it will make it harder to find housing. They'll see you as a bit more of a risk. And sometimes they can charge people more if they think that, or they can simply refuse to allow you to rent with them. There are ways to get these judgments removed. Let's say if you were evicted for non-payment of rent and you end up going back and you pay that amount you owed, that can sometimes be a way to remove that judgment going forward into the future. And then talking about certain things that people are protected for. People with disability are protected, and they're giving what's called reasonable accommodation. So for example, let's say you have mobility issues, then the landlord, if they have an available unit, should be giving you a room on the first floor and not the second floor. If you have a qualified service animal or emotional support animal, that should be something that you're allowed to have with you in your home without having to pay the pet fees. It's important to remember, though, these need to be qualified by a doctor. While there is no specific regulations on what qualifies as an emotional support animal, if you want the protections of an emotional support animal under these disability clause, you would need it to be given a note by the doctor saying that you need that emotional support animal. And of course, landlords can't discriminate against you for disabilities, including mental or physical impairments, or addictions, including alcohol addiction, or any STDs like HIV or AIDS. Landlords can ask for doctor's notes regarding disabilities that require accommodation, but that's only when some kind of special accommodation is required as a result of the disability. So how can you prepare for legal issues before they arrive? First is try and record everything. When you move into a property, you want to go ahead and record the condition of the property. When you let the landlord know about a repair issue, or when you make payments, you also want to record those too. You want to record what you paid and when. You want to record when you let them know about repair issues, as well as the repair issues yourself. Most people have something like this, some kind of smartphone, which makes it really easy. to record everything. It's as simple as taking pictures or video of anything. If you have a something that you send to them through a tenant portal, and it doesn't give you a recording of that, just take a screenshot of that, or even do it on a computer and hold up your phone to take a picture. But you want to have dates of everything that you really communicate, because at the end of the day, when you are leasing a property from a landlord, it's essentially an ongoing business contract, and you want to make sure that they're following all their requirements and that you have proof that you're following yours. That way, if it ever does go to court, you'll be ready to show the court a written record of everything that's been done or hasn't been done by you and the landlord, because courts love to read. They love to read a lot more than they love to hear people talk. And it's a lot easier to present them with evidence instead of having to present them with testimony. So here, I think there are basically some information that you can reach out to beyond legal services ourselves. You can always reach out to us. We're always happy to try and talk and help as many people as we can, though we do prioritize people that are already in court who are facing evictions, because we have so many people to help. We are not always able to provide full service to others. So it's important to reach out to other programs to see what you can do, as well as self-help. You can reach out to Michigan Legal Help Housing Resources, which has a lot of self-help tools, as well as Michigan Legal Help Guide to Legal Help, which basically provides you with a tool to find an attorney if we're unable to represent you in whatever situation you're facing. And that pretty much covers it. I'm happy to take questions for the rest of our time, or if not, I guess you guys can get 10 minutes back.
No, Alex, we do have some questions. We have somebody, we're going to unmute and they can ask their question.
Sure.
Leslie, go ahead.
My question is this: if person has been evicted and goes to a new landlord to get to try to secure new housing, how does that landlord know that the person has been evicted in the past? So
what landlords do is they run background checks on people whenever there's an application for a new tenancy, especially at bigger, landlord complexes. They'll do a background check, and then they'll, in that background check, be able to see information from the potential tenant on their, credit score and their rental history and things like that. So that's where they would be able to find, some kind of record that there was an eviction in the past.
Did that answer your question?
No, I have another question.
Okay.
In Ann Arbor, I'm with the Ann Arbor Human Rights Commission, and we have a fair chance access to housing ordinance that is supposed to prevent landlords to look at to do a criminal background check. And if this so I don't know how that works.
So the eviction is a civil case, so it's not a criminal case. So even if they don't look at the criminal history, they could still see other civil histories. So civil and criminal court are kind of different. Criminals when you break the law. Civil is when you break a contract or an agreement.
Okay, did that answer the question?
Yes, thank you.
Okay. All right. Is there a time frame in which a tenant can remove a judgment of eviction from their record if they pay those fees? For example, there's a tenant that owes a few $1,000s to a private landlord she's lived in about 5 years. Can she still pay that fee and get it removed from her record?
Okay. So yeah, I don't believe there's any specific timeline of when to pay those fees. So I'm assuming she was evicted quite some time ago. Is that what's happening, or? Or is she not evicted yet? She's facing eviction for some amount of money.
It sounds like that the person maybe had a previous eviction and wants to get it off their record.
Okay. Yes. So what you can do, the best way to do that is contact that previous landlord and see if they're willing to work out some agreement and basically say, if I pay this amount of money, it might not even be the full amount of money. Are you willing to basically send in a stipulation to remove that judgment? You can also remove it without, basically them stating it by showing proof of payment to the court. But the best way to do it is simply to reach out to whoever you owe that money to and say, if I give you this money, are you willing to send in basically a documentation to the court that shows that I paid this and that you want the judgment removed? And again, that's also something we can help, walk you through if you reach out to legal services.
Okay, and I think this is kind of a follow-up to that. It's like, how long does the eviction say on your record? So I'm assuming that once it's paid, how long does it stay on the record?
Well, before that, if I remember correctly, and don't quote me on this, but I believe an eviction judgment will stay on your credit history for 7 years. So if it's past that, or if it's close to that, it might be, even worth not dealing with. Now, how soon it would be taken off, it really would be a matter of how quick, I guess, the court addresses the issue. It could be, a week or two. It could be a month or two, depending on how long that court processes it once the stipulation is sent in. That shows that, the money was paid.
We have another question. What are tenant rights if they are not on the lease or the primary leaseholder?
Yes, so I did see that question before. And it depends on how things go. Technically, you do not need a written lease to be a tenant. If you're in a month-to-month situation where there was no original lease, you can continue with no original lease. It's always better to get a lease. I definitely recommend it, as it outlines, all the rules and whatnot and the agreement. But if you are simply a month-to-month, technically you don't need a written lease to go through. But if what I think they're asking is, if there is a written lease and you're not a tenant there, you might not have any rights, unless you're under 18, one of the children of the people living there, unless the lease specifically says that you're authorized to live there. You would want to be on that lease somewhere, or else they may be able to evict you and the person living there for having an unauthorized tenant at the apartment. Now, obviously, they would still, I believe, have to evict you as a tenant, but it would be an unauthorized tenant, and you would have a lot less defenses to that claim.
Does you have some questions?
Go ahead.
I have an apartment complex that is there, I'm going to call it bully tacting. The landlord there has a tendency to say she wants all of Section 8 out. Can you actually do that? Because she's already bullied some and they're gone. My thing is, I feel bad for some of them because now they didn't, like you said, you don't have to do anything wrong to be evicted. And I don't think it's fair that they're now gone and now they've got a record for their, their credit record. Is there anything we can do, like take our story to the judge on our own? There's got to be protection for these people. It doesn't make sense that the landlord can do this.
Yeah, and I'd have to look into those specific cases, what reason she's claiming to evict them for and what defenses they might have. But people who do receive Section 8 do have special, defenses that others do not. They do need, just cause for that eviction to go forward. But then there's also the thing that landlords can refuse to continue with Section 8 programs There's certain ways they would have to go about doing that properly. If they decide to end that, typically, if you're on Section 8, you're going to have a Section 8 lease, which is going to outline what your portion of the amount of rent is and what the Section 8 is. And that can also change, depending on income. But yeah, to really look at that, we'd want to see, what the reasons they're trying to evict these people are for, how they're trying to end the Section 8. Are they just trying to evict these people? Are they not renewing the leases? What method that is, because that is something that we do see every now and then is a previous landlord who was willing to accept Section 8 either is under new management or simply no longer wants to work with them, and they slowly basically look for reasons to get rid of people.
Yeah. Okay. She just has a follow-up
Yeah, can I
question.
just do one more?
Sure. Yeah, of course.
It's been, okay, some people have been waiting 5 years to get repairs done. What kind of timeline can we go after them again? And they're still not doing it. What do we do at that point?
Yeah, so like I said, the one thing that's always important to do is make sure you try and document it, because then you can show a record of how far this issue has gone back, and that this is continuous to the property. And you also want to see if you can try and get the city inspectors involved, either the city of Ypsilanti Township, city of Ann Arbor, so they can come out. And then now you have not only your record showing that these repairs aren't being done, but you also have a third party governmental record that these issues are ongoing. And then of course, the last step that you can do is, if they're still not doing this, if they're still not making these repairs, even after the city tells them to, even after you've told them to, and you have all these records showing this, you can just simply stop paying the rent. And nothing makes landlords work harder than not getting money. They may try and evict those tenants for non-payment of rent, but if the tenants, can properly show these repairs aren't being done, I have the money and I'm willing to give it to them, and the courts will often make the landlords make those repairs in order to give them the money, and they won't file an eviction. Of course, that also gives some risk to the tenant, because then they have to go through the court proceedings. But if they do have those, documentations showing that, and they are willing to pay the rent at the end of the day, then they don't really have to risk an eviction judgment, because they always have that money that they can pay.
Thank you, Alex.
Well, I hope I was able to answer everyone's questions. I hope this was at least somewhat informative, giving you guys the brief overview. And again, legal services is always willing to talk in more detail about any specific issues people have, or any specific, claims they're worried about, or whatnot.
All right. I do have one more question. I'm sorry, if you have the time.
Sure.
And then we're going to just go ahead and wrap up. Does a 7-day notice for non-payment of rent go on a tenant's record, even if the tenant pays the rent before the summons is filed?
No, it shouldn't go on your record, because the 7-day notice is just something that's sent between you and the landlord. So the landlord drafts it up and they send it to you, and no one even has to know about it between the two of you, unless you share it with someone else or the landlord. And it certainly does not go on a credit record or anything like that. So that's not something you should worry about. If you get a notice and you pay it, that shouldn't be an issue.
Right. Thank you so much, Alex. Hopefully this was helpful for everyone. And we put a lot of information in the chat. We're going to go ahead and get this out as well. If you have additional questions, then you can always ask Legal Services or Washtenaw Housing Alliance as well. So thanks for attending, and have a great day. It's Friday. Yay.
And thank you for giving me the chance to talk. Have a good weekend.
Bye.